afternoon. Nice to see a full crowd again. It shows SASLAW hasn't lost its popularity. Welcome to the first seminar for 2020. Hopefully it will be an interesting topic. I've been asked to remind everybody, please pay heed to the invitation to submit papers for our next annual conference by the 10th of February. We'd like a lot of interesting papers and some interesting speakers. Let's keep the high standard going. That being said, it's my pleasure today to introduce to you Neil Coetzer. A lot of you know him, and we come across each other in our small labour community all the time. Neil is a partner in the employment law department at Cowan-Harper-Madikizela. He joined the firm in 2009 and holds a LLM degree. He's also done his privileged duty of acting as a judge in the Labour Court in the 2018 recess. He's going to tell us today about all the interesting cases that came out of the Labour Court and the Labour Appeal Courts and related courts pertaining to employment law in 2019. And as you'll see, there's quite a few of them. So that being said, let me immediately hand over to Neil to come and tell us about the law in 2019.
When I was asked to do this talk last year, it was in December, and I enthusiastically accepted. And then I had a nice holiday and I came back, and I realized that this was an enormous task. And I stand before you a humbled man. And you'll see that it was another busy year for labour lawyers. We say this every year, but it seems to get busier every year. And there are more and more issues arising. Nothing ever seems to be settled finally. Everything is conflictual. And there were over 200 cases that were reported in the ILJ during 2019, which is staggering. And there's almost 70 just from the Constitutional Court, the Labour Appeal Court, and the SCA. And there was another one today from the Constitutional Court, split 5-4 again, very close. So lots of disputes covering almost every conceivable aspect of employment law. Lots of dishonesty issues. I decided that because I can't cover all of the topics, and it's my talk, I've decided to do the cases that I want to. So I've decided to choose themes, and I've just kind of populated those themes based on some of the cases that I found. Looking generally, South Africa is still very much a conflictual society, and I don't think that will be over anytime soon. There's political instability, a weak economy, highly regulated labour market, high levels of unemployment. These are all significant contributors to our workplace being a conflictual place. Having said that, employment law remains a dynamic and exciting field, and you can see from the turnout that this is true. So let's get into it. The themes that I've chosen, hopeless cases and cost orders. This has become a bit of a hobby horse for me. So what I've done, because they're so prevalent, is to pick some of the ones that I found interesting, and then I'll have a little extract from the judgment to give you an idea of where the court is going, particularly the Labour Court, in relation to these issues concerning hopeless cases. Damages claims in the employment context, this started in 2018. There was a massive claim that was launched in the High Court, and it's followed through, perhaps not to the extent that some of us had hoped for. Disciplinary inquiries and resignations continue to be an issue. Labour lawyers still struggle with this, and it's a constant area of litigation. And then violence and third-party involvement in the workplace. This has been happening for a long time, but it's starting to come through in the ILJ and in the reported judgments more and more. So I thought it might be useful to actually just reflect on what happened in 2019. So hopeless cases, that's the new buzzword in labour law litigation. There's a warning issued, as we know, by Judge Van Niekerk in Mashishi versus Mdladla, and there was a warning there in those words that those who appear in this court should be aware that in future the pursuit of the hopeless case will attract consequences. And I think in general, 2019, we saw that warning fulfilled by the Labour Court. The ILJ is full of cost orders, which is refreshing, I think. particularly if you're a labour lawyer. and you have to explain to your colleagues in general litigation why you don't get costs with the matters that you win. So I think it's a good change, and it would serve as a good deterrent in future. So there's a substantial number of cases involving it. The first one is Sepeko versus DuPont. This is an application for leave to appeal containing various allegations which was questioning the integrity of the labour court. I'm not going to go into the facts too much. I imagine that many of you would actually have read some of these cases, and there's a lot of cases to get through. So what the court found was that the application constituted an abusive process, and that the employee had actually resigned before he was retrenched. So I mean, it's kind of pointless to pursue any sort of unfair dismissal dispute in those circumstances. And the employee's counsel had engaged in unacceptable conduct and an unjustified assault on the integrity of the labour court. So what the court said here was, it must also be considered that legal practitioners practicing in this court are part of a profession that demands complete professionalism, honesty, reliability, and integrity from its members, and who owe the court a duty to be truthful and maintain an appropriate level of professionalism and courtesy. Where legal practitioners make unsustained and unwarranted attacks on other litigants or witnesses or judicial officers, it displays the kind of unprofessionalism justifying a costs award day bonus programs. Next one is Telkom and Mashaba. This was a dispute concerning an amount of back pay. The employer had calculated the back pay in terms of the prescribed rate of interest act, but the employee's attorney had calculated it apparently in terms of section 75 of the BCA. And this was not a small discrepancy because the employer had calculated an amount of about 700,000, whereas the employee's attorney had calculated an amount of 27 million. So there's a bit of So what the Labour Court said was that the employee's attorney should be held accountable for persisting with this incorrect calculation. To persist with his calculation and arguments, Mr. and I've taken the name out, did not merely make an error of judgment, and his conduct does not indicate bona fide. He acted in a manner that constitutes a departure from their office by persisting with a calculation which they should have known was wrong, forcing the applicant to come to court and persisting with the absurd calculation of the interest in court made matters worse. This court's displeasure should be known to the attorneys. Right, and in this case, you had an application to have a settlement agreement set aside by way of a review application. The Labour Court finds no prospects, wrong legal approach, but the employees had been advised to pursue this route by their legal representatives. And here, cost day bonus probe is ordered again. The court said here that in Casa it's evident that the applicant's attorney filed an application without any reflection as to the provisions of the LRA, without any consideration of the applicable case law, and whether the matter should indeed be pursued. One could reasonably accept that a practicing attorney assisting a paying client should at least consider the law, the applicable legislation, the merits of a case before an application is filed and before other parties are dragged. These are strong words, but I think they need to be said. This one came out late last year. It's not reported. This was a clever argument that was made by the SABC. I think full marks for novelty, but Labour Court gave it 0 out of 10 for the law. So SABC contended that where an employee misconducts him or herself, the employer could treat the case either as one of misconduct or as a breach of the employment contract. It further contended that since it, being the SABC, had decided to treat the misconduct as a breach of contract, the issue of lawfulness arose, and therefore the CCMA lacked jurisdiction to deal or to arbitrate such a dispute. Now, obviously, the Labour Court found no merit in this point. It said that if this point was accepted, employers could avoid the statutory consequences of the LRA simply by casting a termination of employment in contractual terms. Now, there was an allegation made in that case that the SABC had simply engaged in this litigation as a stratagem to deny this employee an opportunity to have her dispute arbitrated. And the court said that There's a difference between the robust defense or advancement of one's interests and a conscious strategy to deny an employee access to justice by resorting to the superior resources and funds that an employer inevitably has at its disposal. Indeed, the employee avers that the present application is an element of a broader tactic to deprive her of the right to have the matter expeditiously finalized. There is no replying affidavit denying that averment, and on the face of it, the employee's summation of the SABC's motives is correct. And here we had, although it was a provisional order, made against the attorneys to pay the costs. I don't know what's happened subsequently, but also a very serious order. This happened in December, where there was an application for condonation for the late referral of an automatically unfair dismissal, and the Labour Court found that there were no prospects of success set out in the application for condonation in respect of a dispute concerning an automatically unfair dismissal. So what it had also found was that the decision to transfer the dismissal to the Labour Court as an automatically unfair dismissal was the decision of the attorney, and that the employee was a victim of manifestly wrong advice. Here the court said, lastly, I do not believe that it is fair for the applicant to pay the costs of the respondent and still pay the fees of her attorney. Had the attorney not conjured up the advice, the referral and this application would not have been conceived. Thus, the appropriate order to make is to deprive the applicant's attorney to charge any fees for this matter. It is hoped by this court that this type of order would send the message to practitioners not to bring hopeless cases before this court. This chorus has been sung for almost a decade now. So these are kind of, I've cherry-picked these, and these are really good cases, and I think we can get an idea of where the Labour Court is going. I don't think they're going to turn back now. And I think that given the relentless tide of cases that's landing up in the Labour Court, and even at the CCMA, I think we're going to see more of this. The CCMA doesn't really have a filter to deal with cases, and I think many of us spend hours at a time dealing with things that really shouldn't be taking up our time. And I think this is one of the important steps to take in dealing with these issues. The next theme that I want to deal with is damages claims. And as I mentioned earlier, in 2018 there was a case in the High Court of Sime, Darby, Hudson and Knight. What happened in this matter was that an employee had very cleverly diverted sales away from his employer to his own companies. He purchased the same products and set up companies in competition with his employer secretly, and would offer reduced prices and then shift the orders to his own companies. So the employer here claimed and was awarded damages amounting to more than 40 million rand. And that claim was based on a breach of the duty of good faith. So it was a common law claim. It was very interesting. And I'd encourage you to go and read that case if you haven't already done so. And I saw this as an encouraging trend in our employment law. And I was hoping for more of this, given the amount of corruption and state capture that's going on, let alone dishonesty in the workplace. I would have hoped that more of this would happen. The only case that I found was unreported, unfortunately, but it's made a lot of waves in the media. And this was concerning Mr. Ntunkulu, who was responsible for the trains that don't fit on the track. So what happened here, this case is interesting for two reasons. Firstly, for the sheer brazenness of the dishonesty is just staggering. And you'll see why now. But PRASA investigated the authenticity of Dr. Ntunkulu's qualifications and asked him to provide copies of all of them. It did this after News 24 published an article questioning the authenticity of his qualifications. So after he received the request, he called in sick, as one does. But he had an envelope delivered. And the envelope contained a degree certificate, a diploma, and a letter from the Technische Universiteit München. Now, this stuff you can't make up. The next slide is a quote from the judgment, and I hope it's right because it's hilarious. So, this was the content of the letter. It said, "To whom it may concern, We confirm that Dr. Daniel Ntunkulu obtained this recognition since he did his research work in Germany as part of the collaboration with the Technische Universität München, focusing and specializing in rolling stock and networks. This serves as recognition for his great contribution into the various. Testimonials can be sought from various experts in the field. Yours sincerely, signed Professor Fraudenstein.
Shouldn't it have been Frankenstein?
So big surprise, the qualification. And he immediately resigned. So Prasa instituted a claim for damages. That claim was based on a fraudulent misrepresentation, which is clearly evident from that. And there were two claims. The one claim was for him being appointed on the basis of a CV that was fraudulent, because he had listed all of these qualifications. And the second claim was based on an increase which he sought. And he had then said that, well, I should be paid more because I have this doctorate degree from this institution. The difficulty, and this is the second reason why this case is important and interesting, is because Prasa's administration and record keeping was in a very poor state. It's an SOE, it's been gutted by corruption amongst other things, and many witnesses have either been dismissed or fired. So getting the relevant documents to actually institute a claim would be quite difficult. So the employer here was forced to rely on hearsay evidence. And the probative value of that evidence was high, at the court found. And in any event, Ntunkulu hadn't disputed much of it, frankly. The hearsay evidence was corroborated by Prasa's witnesses that they could secure. And in any event, it was in the public interest to allow that hearsay evidence. So the employee's defense was unconvincing. He denied any knowledge of wrongdoing, argued that there were many who were intent on destroying his career. Of course, he didn't deal with that letter that I showed you. And he also didn't deal with any of the emails where he had instructed the IT department to update his email signature as Dr. Ntunkulu, which he insisted on. So he was then punished in the amount of 5.7 million rand, which had been awarded against. So, I think before we get to the next case, I think that this is a very important case, and I'd like to see more of this. I think we live in a society where there's a serious and severe lack of accountability. We have a state capture commission that has run out of time, and they're asking for more time because there's just so much that they haven't dealt with. And I think that where possible, employers should be playing their role to recoup some of these losses that have been incurred. Of course, it's not always easy. The next case, I think, has had people kind of scratching their heads a little bit. I'm not sure how I feel about this case, to be honest. This is an employee of a security company who had robbed and murdered an employee of Bidvest, a client of the security company. Now, the facts are long and convoluted, so I don't want to get into them, but essentially the employee had entered the building after hours using an access override key. So he was the security manager and he had the access key. He could access that building at any time and without arousing any suspicion, because that's where he was supposed to be. He's allowed to make unannounced visits at any time. So when he waltzed in at 6 o'clock in the evening and held a gun pointed at Mr. van Staden, nobody, well, obviously they would have questioned the gun, but when he walked into the building, nobody suspected why he was there. They just thought he was doing his job. So he went straight to the financial manager's office and pointed a gun at him and demanded money. And after that, told him to get into the car and shot him in the car. So, it's just really terrible facts. Now, what happened here was that the employee's widow then sued the security company for damages based on vicarious liability. And it's not something we hear often these days. It doesn't happen very often for employment lawyers. The general principle, of course, is that the employer is vicariously liable for a wrong committed by an employee during the course and scope of their employment. And that's the one we were always taught at university. Now, based on considerations of public policy this is the notion of vicarious liability. But because public policy changes, the law must change as well in relation to vicarious liability. So what the court found here was that the employee here had committed this wrong entirely for his own purposes. It's not in any way connected to the course and scope of the employer's business. But the test has been developed, and there's a sufficiently close link must exist between the wrongful act and the business of the employer. Now, the SCA was faced with the question, should this rule include the creation of risk of harm by an employer? And the SCA says yes, it should. Whether the employer created a risk of harm must be determined objectively. Now, on these facts, the murder was sufficiently closely linked to the security company's business for the following reasons. The employee was allowed to enter and exit Bidvest's offices without detection. The employee had intimate knowledge of the offices and the security systems. The employee was instructed to make unannounced visits to offices at any time. He knew that Van Staden would be working late. The company provided the employee with an override key, so he had complete access to the unfettered access. The security company had a contractual duty to protect staff and the property of Bidvest, and they had placed the employee in charge of that function. The employer, in these circumstances, the SCA felt, should be held vicariously liable for the damages caused. And this was damages in the amount of 1.6 million. Now, I'm sure that every security company in the country operates on this basis. And there may be other employers that now need to think about the way they structure their operations. Do they create risk in the way that they render services to some of their customers? These vicarious liability issues could come back to bite them. The third theme is disciplinary inquiries. I know from my own practice that disciplinary processes are still plagued by formalism, and we see it all the time. And this is particularly so in the public sector. And disciplinary inquiries take far too long. Too many reviews of chairpersons' decisions brought by employers in the public sector. So we've actually had situations where the Labour Court has complained about the number of employees applying to the Labour Court for interdicts to try and stop the disciplinary inquiries. And now we've had the Labour Court commenting on the number of employers actually seeking to overturn the decisions of the chairpersons that they engaged. The disciplining of employees who failed to give proper notice of their resignation was a massive issue for debate last year at some point again, thanks to an earlier judgment of the Labour Court, but I think that's been resolved now. And I think maybe let's kick off with that case. So in Naidu and Standard Bank, these employees resigned with immediate effect upon receipt of the notification of a disciplinary inquiry, which generally I think is a clever move, in breach of a 28-day contractual notice period. So the employer said, well, we don't care. We're proceeding with the inquiries, which they always want to do. And the employees then approached the Labour Court to obtain the interdict. So the Labour Court here confirmed that resignation was a unilateral termination of the employment relationship. The Labour Court found that the employer was not entitled to discipline the employee after resignation had taken effect, because there's no relationship. It's obvious. The employees who resigned with immediate effect breached their contracts. Yes, they did. And the normal contractual remedies were available to the employer. Those contractual remedies were to cancel and claim damages, or to seek an order for specific performance holding them to their contracts. In fact, in the judgment that was sent around today by SASLAW, there's a discussion on this issue about specific performance in trying to hold employees to their contractual terms. And it's difficult. Courts are slow to enforce those because it would almost amount to servitude, where you force an employee who you're supposed to trust to work with you for another month. That doesn't make sense, just so that you can fire them. So the employer is not entitled in these circumstances to refuse to accept an employee's resignation because it's a unilateral act. It brings the employment relationship to an end. And the employer was entitled to seek an order for specific performance, but it didn't do that. And therefore it could not continue with the disciplinary inquiry. So I think that resolves the issue. I don't think there's any more confusion on it. I mean, the purpose of a disciplinary inquiry is not punitive, or it should not be punitive. The LAC has said to us that a dismissal is not punitive. It's minimizing operational risk. So if the person is resigned, your operational risk is gone, at least to a large extent. Yes, there may be reds inquiries and other things after that, but those can be dealt with. EOH Ubuntu, anyone who has a mother-in-law is a good case to talk about. So what happened here is that the employee, his mother-in-law couldn't activate the software at home. So he thought he'd do her a favor and send her a software license key to activate it. Apparently he sent one that belonged to the client of his employer. So that's bad. And the employee claimed he was negligent, but the employer charged him with those classic words in a charge sheet: theft, fraud, dishonesty. Found guilty, and he was dismissed. And then the CCMA found that his dismissal was unfair because he had only been found guilty of gross negligence, which was not what he had been charged with. And the Labour Court agreed. They said the employee had been charged with dishonesty, and the employer had not proven his dishonesty. So, go back to work. The LAC, however, found that there is no requirement that competent verdicts should be mentioned in charge sheets, subject to the caveat that employees should not be prejudiced. Prejudice will normally only arise where the employee is denied knowledge of the case he has to meet. So, I mean, essentially the Labour Court found that by not sanctioning the employee for the negligence, it had actually committed a material error of law, and it found that dismissal was the appropriate sanction. And review set aside. In statistics, SA versus Molabatsi, here you had an employee who was charged with interfering in the appointment of another employee. It wasn't so much interfering, it seems more a situation where the employee in question hadn't complied 100% with the recruitment policy. But when viewed holistically, it appears that the employee who had been employed wasn't his cousin or a family relative. It was actually a very good employee who had been used within the organization, so there was minimal risk to the employer. The disciplinary chairperson found him guilty, but imposed a sanction of 1 month suspension without pay due to the mitigating circumstances. Now, the employer applied to the Labour Court to review and set aside the chairperson's sanction. The employer obviously wanted him out of it. Now, the Labour Court actually commented to say that it was concerned by the growing number or the growing practice of reviews by employers. Even though Section 158(1)H allows reviews, it does not mean that the Labour Court should be the first port of call if employers are unhappy with a decision relating to its internal processes. In other words, the Labour Court is saying that we are not here to make your decisions. Make your own decisions and come here if you can't resolve them following those decisions. Now, these reviews place an undue burden on the Labour Court. The Labour Court found that state departments should rather appoint competent officials to preside over disciplinary inquiries. I think that's a good place to start. Employers are using the Labour Court as a backup plan, and this constitutes a misuse of the court's resources. So the Labour Court found that the chairperson's decision was perfectly rational and dismissed the review. Right, and then I want to move on to violence and third-party interference. You could talk about this for most of the evening, actually. And it should probably have a dedicated evening just to deal with that. But again, it's been a very violent year, or 2019 was a very violent year. Lives were lost again during industrial action, and no one seems to have answers anymore. It just seems to be par for the course. And we talk about the codes of good practice, and we talk about the amendments to the LRA, but the reality is that very little is changing on the ground. We're still seeing violence, we're still seeing inter-union rivalry, seeing intimidation. And I've kind of cherry-picked, I think 5 of more than 20 where violence and intimidation was present. And some of them are quite sickening, to be honest. But what it does show is that our industrial relations are still rooted in adversarialism and power play. And this goes to the comment I made earlier about the conflictual state of our society. we haven't really seen the fruits of Section 150A as yet. And hopefully they will bear fruit. But as Anton Meiberg indicated last year, it requires the parties to want to engage in that process. And where they're polarized, that probably won't happen. So one very positive development, though, is the picketing rule requirements, which have been implemented in Section 69. I think they've been effectively used by employers. Probably not as effectively as they could, but I think it's a useful amendment to the LRA. Sadly, I think that with the exception of one or two unions really have lost their way. And I see this on a weekly basis. I'm sure many other people sitting here feel the same way. But unions are not concerned about their members any longer. And there seems to be a jockeying for positions and political office. So what it leads to is loss of life and conflict and a lack of rationality, unfortunately. But what it means is an alienation between members and the unions. And where that happens, you have political parties, the community, and other organizations that are stepping into this void to take their place. And frankly, they're actually putting up a fight. But the problem is that they fall outside the scope of the Labour Relations Act. So it's not entirely clear how we should deal with these developments as yet. The LRA doesn't deal with this issue. But what it does result in is a complete destabilization of the workplace. And that's the issue that we need to deal with. So whether the LRA is fit for purpose at this stage is a debate for another day. But it's certainly one of the issues that are emerging. And we're starting to see these things come through in the case law. So this is the case of Walsh. He was employed as the CEO of Fort England Hospital. The institution was in complete disarray, and he vowed to fix it. Unfortunately, the measures that he sought to implement were met with resistance and defiance by every single union that was at the hospital. The unions and members then engaged in a concerted campaign demanding the removal of the employee. The union encouraged unprotected strikes, unlawful and criminal conduct. It threatened to make the hospital ungovernable, threatened the safety of the employees, patients and staff, threatened to destroy property and burn down the hospital if their demands were not met. The court interdicts that were obtained were ignored. The employee was asked not to work because his presence provoked violence. How can you ask a CEO not to work? So the department then took the decision to transfer him to another hospital in terms of the Public Service Act. And this is tragic too. So he sought to review that decision, and he argued that the transfer was made following an unlawful demand by the unions. Now the Labour Court found that, there were other arguments made, but I'm not going to deal with them. The Labour Court found that although the conduct of unions was unlawful, it did not necessarily mean that his transfer was invalid. The court was only entitled to intervene if the decision was arbitrary or inconsistent with the purpose of the transfer. And public interest was the criterion against which the decision had to be assessed. So the decision to transfer was clearly motivated by a basket of factors, which extended beyond the employee's self-interest. The employee's interest could not outweigh what was in the broader public interest. So the decision to transfer was neither irrational nor arbitrary, and it was not actuated by bias or malice or an ulterior motive. But of course the bigger question is, why was there a capitulation to the demands of the union? Why was this anarchy allowed to perpetuate for such a long period of time? And that's what the Labour Court asked. It was critical of the union's conduct and the employer's capitulation to the union's demands. So here we have a situation where the workplace is completely ungovernable, where the CEO cannot work. And instead of dealing with those issues, the department's response was to transfer the person who tried to fix the institution. This is scary stuff. There were 5 or 6 Sibania judgments, and I'm not going to deal with any others. But this one is interesting because of the picketing rules. Here the CCMA issued rules allowing picketing at three sites, and it had placed limitations in respect of each of those. The strike, unfortunately, as we all know, was marred by violence, unlawful conduct, and violations of picketing rules. Sibanye then applied to the Labour Court, seeking a variation of the picketing rules in terms of Section 6912, to limit the picketers to one site and to no more than 50 at any given time. I think that was a bit opportunistic, but worth a go. Now, the Labour Court found that the picketing rules issued by the CCMA should be upheld, enforced, and applied because they're a good thing. We're moving towards regulated pickets. It's fantastic. The Labour Court, however, is entitled to vary the picketing rules where the application of those rules may undermine the objective of peaceful demonstration contemplated by Section 16. That's the overriding concern, I think. So the Labour Court then varied those picketing rules, reducing the picketing areas to 1, limited the number of picketers to 500 at any time, and ordered that employees were not permitted to hide their identities while picketing. Also very important. Discount pharmacies was another strike that made the news. Complete anarchy at one point. This was a national strike where the CCMA had actually issued picketing rules. There were violations of those picketing rules, unlawful conduct, violence, and intimidation. Urgent interdict was granted, but it had no effect on the conduct of the strike. The SAPS was required to intervene on several occasions. The company and the CCMA's attempts at engagements with the union failed. So I mean, this was just complete lawlessness. The company approached the Labour Court for relief in terms of Section 6912 of the Labour Relations Act, and the Labour Court found that where the objective of a peaceful picket is contravened, can lead to the forfeiture or suspension of that right. And this is in accordance with the new amendments. Again, I think there's a positive development. Section 6912 allows for relief which is just and equitable and may include the forfeiture and suspension of the right to picket. The court found that the conduct of the strikers was unacceptable, and the conduct that they displayed showed contempt for the Labour Relations Act. And the orders of the Labour Court and their conduct, was irreconcilable with the notion of a peaceful protest. So the Labour Court then suspended the picketing rules and interdicted employees from participating in any further picket, gathering, assembly, or protest action. So this is a protected strike where a picket can no longer take place. Very interesting. And quite a radical change from 2 years ago. This case is great. Pale print. Here you had a disciplinary code of an employer which prohibited brandishing or wielding of dangerous weapons. Now, during a NUMSA national strike, employees carried sticks, a shambok, a length of PVC pipe, a golf club, and for good measure, an axe. Just in case they didn't get the message. So employees were charged, and they were obviously dismissed. Now, what's surprising is the finding of the CCMA and the Labour Court, where the CCMA found that the dismissal was inappropriate because for a number of reasons, but because the charge of assault in the disciplinary code carried a sanction of only a final written warning. The employees had only partially breached the rule because they only carried sticks. They did not brandish or wield them. And the court also found that this is the craziest thing. Sorry, this is the CCMA. Also found that the disciplinary code did not apply when the employees were off duty or not on strike. Or on strike, sorry. So the employees were reinstated, and the Labour Court then dismissed the employer's subsequent review. The LAC, thankfully, found that the commissioner had misdirected himself. The rule was valid and reasonable. There's no dispute about that. And employees' conduct clearly breached the rule. And it said that unduly technical approaches to framing and consideration of charges should be avoided. And I think we all know this now. And I think we should make an effort to actually comply with this. The commissioner had lost sight of the context and reasons for the weapons being carried by the strikers. I mean, they weren't there just because they happened to have them on that day. The employer was entitled to prohibit weapons from the picket line, to ensure the safety of the premises and its employees. And the LAC found that the right to strike did not encompass a right to carry dangerous weapons, which is obvious. And the dismissal of the employees was found to be fair. Right, so this is, I think it's the last case that I want to deal with. This is kind of, I know there was a previous judgment by Judge van Niekerk dealing with EFF arriving and waving banners at the workplace. This one, we see a far more brazen intervention from, I would go so far as to say, a neo-fascist political party at the workplace. Now these sort of interactions hold serious implications for the workplace. What happened here was that the EFF representatives had arrived at the employer's premises and held a meeting with several employees. There was a letter then sent by the EFF to the employer advising that the EFF had been mandated by employees to intervene in alleged grievances of employees with the employer. There were a number of grievances raised. I've only listed some of them, but I mean it was a real laundry list of grievances. The EFF then delivered a memorandum giving the employer 7 days to comply or face mass action. So a go slow started shortly thereafter, and that progressed into a strike, and then there was a protest which the employees then also participated in. So the employer approached the Labour Court to obtain a rule nisa and an urgent interdict restraining the EFF, amongst other things, from interfering in the employer's business. The EFF indicated to the Labour Court that the employees, and this is brazen, that the employees would not resume their duties regardless of the court order or the provisions of the LRA. This is the start of the breakdown of the rule of law. This is serious. The employees subsequently dismissed, they were then obviously dismissed because they refused to return to work. On the return day, the EFF then argued that the employees should be reinstated and that the employer be compelled to negotiate with them. The Labour Court found correctly that the LRA is designed to ensure that workplace issues are not dealt with by political parties. It's apolitical, and that's the beauty of it. The EFF's reliance on the Constitution was entirely misplaced. They obviously said there's a constitutional right to fair labour practices and whatever else. So the EFF had in fact undermined orderly collective bargaining and dispute resolution, and it was ordered to pay costs. Now we've seen this more and more. What we've also seen is community organisations demanding tenders. We know about the construction mafia, all of these things. And these are the sort of things that employers now have to deal with. And I don't know if employees are ultimately the beneficiaries of these initiatives. In some instances they may be, but in others I'm not so sure. So, yeah. So 2020 I think will be hopefully an interesting year. And I hope that you've enjoyed the talk. Thank you very much for listening.
Any questions you would like to ask before we end with that? Yes. Let's see.
Yeah, Neil, is it not your sense that the Labour Court in general terms has responded a little bit slowly in relation to the issue of violence? That it seems to be coming to terms with the issue now, but at one stage one got the impression that it was almost rationalising or sentimentalising violence and not really wanting to deal with it. I think of a recent case where 70 employees beat up a manager and they were reinstated. Transvaal Nut and Bolt, it's unreported.
Yeah, Rod, I think that the Labour Court has perhaps been slow. I think there could be some criticism levelled at the Labour Court. They've tried innovative remedies, possibly looking at declaring the strike unprotected. Dealing with the issue of violence is a different issue, though. Perhaps limited by what's set out in the LRA. You know, the Labour Court is unlikely to become an interventionist court. I suppose they would have to work within the constraints of what they deal with. And the Labour Relations Act, I think, could probably deal more explicitly with the issue of violence. But it does seem to me that they've turned the corner on some issues, such as cost orders. And particularly, I think that in cases where there are unprotected strikes, there should be more cost orders made. I think the Labour Court is still perhaps too soft on that issue, particularly where there's an established bargaining relationship. I understand the rationale, but sometimes I think that excuse is used too easily.
Anybody else?
Just on the vicarious liability one, was there no consideration regarding reasonableness? Because you think about the Employment Equity Act, there's that notion of the employer was aware or reasonably expected to be aware. Was there no consideration there? I mean, you can imagine if there are procedures for employers to vet their security guards, that they're not crazy or shouldn't carry license, shouldn't carry firearms.
Yes.
And this employer of that security guard had failed to follow that sort of process. But absent that, obviously I need to read the judgment, but absent that, it does seem like quite a stretch.
Yeah, do you want to add it?
I just want to tag on to that, because what I thought the court didn't do is they didn't place a lot of emphasis on the fact that the employee's behavior before he committed the murder was he's displayed certain signs of he was absent from work, and they even called him into a meeting, and he said he had a lot of debt, and he showed certain signs, and I think the court should have placed a little bit more emphasis on that, because otherwise it's quite a dangerous judgment.
I agree with both of those comments. Interestingly as well, you read the judgment. So what I didn't deal with was that the employee who committed the murder was actually an excellent employee up to a point. The employee had in fact been appointed as simply a security guard, who was then promoted at the request of Bidvest to become the security manager. So as far as the security company was concerned, this guy was great. The client loved him. He was a really good employee. He was a trustworthy guy. They gave him the access key. And the judgment unfortunately doesn't deal with the issue of reasonableness, as far as I can recall. I don't know if you recall it, but I can't recall the issue of reasonableness entering into the equation.
Yes.
Neil, just on the Naidu judgment, with execs, you're normally dealing with a considerably longer notice period. So what happens if you've got a 6-month notice period and the employee is about to duck a disciplinary inquiry? Are you still stuck with notice if you can't dismiss?
Has he terminated? Has he just said, cheers, I'm going?
Well, if he says, can you dismiss? If he says, well, I'm sitting,
How do you mean sitting?
I'm going to work my notice.
Oh, I see. If he insists, yes. Then he must go through the inquiry.
But can you if he's resigned?
Yeah, but the notice hasn't expired.
The notice hasn't expired. So it's once the notice has taken effect.
Anybody else? I think that's it. Let's all thank you for a very interesting and informative talk.